they can have more than that also. It is as equivalent to the, in fact 1% company is as equivalent to the private company. That then in that case we have to immediately think that if it is as equivalent to the private company, then as equivalent to the public company only. I already told, but there are few exemptions given, like cash flow statement need not to be given, and meeting can be conducted. First of all, there is no requirement of meeting one person, how they can do the meeting. There also provision is that. That also they consider as a meeting only. What they are trying to say, if one person signs something and he can record that minutes have recorded and meeting has happened. Ministry really so advanced only. And they said that a person, if he signs minutes and give to the bank or some authorities or outside, then he can record it as a minutes passed by the one person by in his own meeting. So that can be recorded now, it's legally permitted. That means a resolution can be passed by a one person in one person company. That is that's a unique provision that I want to inform you. And of course the nominee can be appointed, that's another thing. So I can have X is forming a one person company, X can have Y as a nominee. And Y also should not be should not have formed any company outside, then he will be disqualified. Okay, so one person can have only one nominee, and if in case this fellow is incapacitated or in the death of this one person, then that nominee will step into the shoes of the one person company. So there is an opportunity that like a kind of a bank account where we put nominee name, and immediately on the death of the anything happens to the account holder, then the nominee steps into the shoes of the account holder. Same way in one person company, a nominee will step into the shoes of the one person who is running, something is happening to the one person. And as I told you that only one person, one company, and automatic conversion. See, in case one person company, it reaches a threshold limit. The threshold limit is given 50 lakhs turnover. I think after this he will throw me out. It's not my mistake also, I am given chance now only. I myself given chance now only. And importantly, which I want to say that with the one person company, even if it is formed also, if the one person company does turnover more than 50 lakhs, then compulsorily it has to get converted into private or public company. Same way, if it crosses 2 crores turnover, compulsory it has to convert. Very simple. A one person company cannot be a small company, then it has to become a private company. What is the definition for small company? A company which is having a paid up capital less than 50 lakhs and less than 2 crores turnover or 2 crores turnover. Otherwise it become a normal company, not a small company. Okay. And then one person company breaches this threshold limit, it cannot remain as a one person company, it should necessarily be converted into a private company, a public company. Same way vice versa also possible. Public company and private company also can be converted into one person company. But you should not forget, one person can one time have only one person, one company. Okay. If you convert any other company into the one person company, then again your quota is over. So you can't have another one person company. So better to form one person company so that we have that company and one person company also now. And contract by OPC, this only I was referring. A one person company can enter contract on his own because it's a company. So I can always sign, but we have to wait and see whether he is signing as a director and company how it is signing, and we have to wait and see how documentation can be done on that. But the company name somebody has to sign, and here I am only, there is only one person company. I have to somewhere I have to sign, and it is agreed and accepted contract under law, under Provision of Companies Act. A one person company can sign a contract and minutes can be recorded that contract is signed. And these are the default. I already explained you this. Section 8, I think I'll take 2 minutes to say that what is that section 8. I'll try to close it. As of now, section 25 company which we deal with, where the company formed for charitable and other purposes. Same way now under new act they brought section 8 company, where a company, a private or public company can be formed under section 8 with the object of charitable nature. Okay. What big difference between the old and new, that alone we will see. Earlier there was a confusion going on whether Section 25 company can be merged with any other public company or private company. Earlier that confusion was going on, and there were some verdicts were there, and we were trying to do something like that, but which ultimately we formed opinion it can't be done only. But after a lot of deliberation with the regulatory authorities, now they made it very clear the one Section 8 company cannot be merged with another kind of company. That means from private company or a public company. Section 8 company can be merged with another Section 8 company, or can be demerged as another Section 8 company. That company cannot be merged with any other kind of company other than Section 8 company. What is the procedure for forming a Section 8 company? Same way how we file an incorporation document, same way we have to file incorporation document. Here the major difference is, first we need to take a license from regional director. We have to file all required document, which we are filing a draft document with the registrar of companies. Those documents has to be filed with the regional director, and we have to take a license to run Section 8 company. After taking the license, keep giving that copy to the registrar of companies, the company can be registered as Section 8 company under provision of Section 8. So the paramount important thing is that first to take a license from regional director as Section 8 company, then along with the license we have to file memorandum and article, other documents with the registrar of companies and register as Section 8 company. And there are almost the same thing which we are following in presently the Section 25 company, same parameter only prescribed for Section 8 company also. And object class, as I told you already, register office, now the provision is within 30 days we have to file under old act through form 18. Now the provision got changed that we have to file within 15 days from change of the register office. And commencement of business become applicable to both private and public. This is a quick recap, and we already discussed all that. Probably I'll be with you for discussion. If any doubt in the Companies Act, how much ever I know, I can share with you. These are the forms. Thank you. Thanks for the opportunity.
Because of paucity of time, and we have to hand over the call literally in a short time, I want to just touch briefly on what he did. Maybe it was not having sufficient time to touch the problem that could be faced on a one-person company and how we deal with it. Maybe we should have a separate session on how to deal with a one-person company and what are all the implications that it could have. But he threw one really googly to all of us, saying that the memorandum and articles should undergo a change. Nowhere the Companies Act as such talks about that, but it also says you cannot have an articles or a memorandum clause which is violation of the act. So maybe if any clause of that is restrictive and is against the Companies Act, maybe you will have to go for an alteration. Otherwise, if every company has to alter memorandum articles, the ROC or the professional will have no other work except only doing this. I think that is not what is contemplated. That's my opinion about that. Maybe if there are restrictive clauses that are there in the articles which is not in consonance or in line with the new Companies Act, maybe you will have to do the alteration for the articles. Otherwise, the existing articles will continue. Maybe the other objects may apply to the new companies that are coming in, because already they have diluted the other objects provision, saying that if it is other objects, it is enough. If it's a private company, they can carry it without any restriction. But the public company, a special resolution is required under the old act. Maybe the same thing will continue, because all these are incorporated earlier, so we'll have to have the views once again of the general public. But my view is that it is there, it need not be altered. Now the SIN number, that is what I think is unnecessarily getting into, because already if you want, somebody wants to know your SIN number, the MCA website itself automatically gives. The moment you put the name, it gives you if you want to make any complaint or anything. Why should all my stationery should carry on with all that? Except that some bureaucrat thought somebody investor made a complaint, so he just included it, and it's unnecessary confusion that is created. So we have a lot of things, and especially when a DIN number is taken, and when you go through all the process of the DIN number, why give more or less the same particulars in the form for a director or a subscriber? Because already all that particulars are given in the DIN. That's what I don't understand, because once again everything is repeated and certified. And some of these classes, they indiscreetly brought when the forms were uploaded online. For example, they were taking an affidavit even earlier from the directors that they will carry on with the business. They have given their consent and all that, and then only incorporated the company. Now they made it into law. That's all. What was practice though it was not part of the Act earlier, now has been made compulsory under the Acting provision itself. So I don't think there is much of a confusion except on this one-person company, on this alteration. The only thing is these articles and memorandum. If you are not in tune with the new Companies Act, maybe you will have to undergo for a change. I think with this, we are on to the last session, or maybe if you have any doubts on this specific session to DHANAPAL, or we have last session where a panelist will answer in overall Companies Act. So we move on to that. Thank you very much.
Thank you, sir. Maybe to just prime the query, there is a question here on conversion of private company into LLP. Suppose existing company is converting into an LLP, existing private limited is converting into LLP. Can anyone else create the same company in the name of, for example, if the private limited company is XYZ Private Limited, they want to convert into XYZ LLP, can anyone else create the same company in the name of XYZ Private Limited after conversion of existing company into LLP?
No, no one can create the same kind of. In fact, in the name availability itself, for LLP and company common search only. Suppose XY Limited is already there as a private limited, XY Limited LLP cannot come. Same way XY Limited LLP is there, XY that Limited cannot come.
Further, what is the formality for conversion of private limited into LLP?
Converting private company into LLP, there is a form prescribed, Form 2 and Form 17. Both form has to be filed simultaneously. Form 18, both has to be filed simultaneously to convert. The only requirement is that there should not be any charge registered in the company. If the charge is registered, then we can't convert. Except otherwise, a private company can be easily be converted into LLP. And that new provision has come in the new act, converting LLP into private company. But I just little get confused. The equivalent provision is not there in LLP. As of now, in LLP Act 2009, there is a provision to convert a partnership into LLP and company into LLP. But there is no provision in LLP Act to convert LLP into a different format. But in the present Act 2013, it gives the power to convert LLP into the company. But then probably they will bring that system into place in the website to convert LLP into. Yeah, it is possible, very much possible. I told a private company and public company can be converted into one-person company.
Well, before any other question, I'll have a sweet task for our chairman. We'll request on behalf of every one of us here, the chairman of the session, to pick two lucky person from the lucky draw box.
Otherwise, the numbers may not come.
Okay.
And I quote this log case example. I don't know whether it is certified random sampling or a real sample.
It is a real sample.
Somebody from your company. Oh, it's somebody's name on the back.
Mr. Murugasamy from Tirupur. Yeah. So, can I request Chairman Anand sir to give a memento to the lucky person? Sir, he is a delegate traveled exclusively for this program from Tirupur. He has come along with his two other partners from Tirupur. Thank you, Mr. Murugasamy. We have another delegate, Mr. S. Vasudevan. It's a Companies Act handbook. Thank you, Mr. Anand, sir. Friends, we have overshot by half an hour. I should thank first the organizers, second every speaker right from the morning. Thanks to our chairman, Mr. Balakrishnan, the first session speaker, Mr. Vedanta Ramanujam, second session chairman and speaker, Mr. Dr. B. Ravi, and third session speaker, Mr. Mohan Ramakrishna, the other chairman for the third technical session, Mr. Ramanathan, and thanks to Mr. DHANAPAL, Mr. Anand sir, and most importantly, thanks to all the delegates who are present here from various parts of Chennai and also from various parts of southern India. We have members from Palakkad, members from Namakkal, members from Tiruchirappalli, members from Tirupur, and predominantly many members from Chennai. And most importantly, there are shadow people who have worked for this particular success of this program. They are the team behind Sri Danya, led by Srimati Smita Chirmar and Mr. Ramanathan, company secretaries and partner of CSS DHANAPAL, and their team, entire team of behind them, who have been working meticulously. Actually, this particular third mastermind program, the time limit was very much limited. They had only hardly 10 to 15 days to reach the delegates here. But the kind of confidence and the response we have given for Sridhanya and Mastermind series is tremendous. And on behalf of Sridhanya, on behalf of the organizers, I thank each and